The former federal prosecutor, now he works the defense side of the table, and you see him on London radio and television, on New York radio and television, and San Francisco radio and television, and Los Angeles radio. He's a media monster, both nationally and internationally, when it comes to decoding the very complicated legal stuff that is going on in America. I'm talking about Supreme Court cases, and of course, I'm talking about Trump cases. Without any further delay, here he is, David Katz, everyone.
Hi, great to be with you. I hope I'm coming in
well.
I'm actually in New York City right now. Do I look okay? It sounds okay?
Yes, you look great.
Terrific.
Yeah, you look and sound great. You're ready for prime time. So, David, I want to ask you first about this Florida judge. The judge, Eileen Cannon, we've talked about this case a lot, you and I, during the many months that it has sort of dragged on. She seems clearly to be, she's a Trump appointee, but she seems to clearly be delaying this case in every way possible. But some of the more recent delays now, these very recent delays, seem kind of absurd from a legal standpoint, and that's what's being called out by Jack Smith. I wonder if you could speak to the absurdity, how absurd it is, or you could just give us a framework as to how to evaluate this.
Well, they are kind of absurd, Mark, which is what the commentators are saying. The idea of the presidential personal records, which Trump is making, is so far out that you think that she would have rejected it. Basically, what Trump is saying, and it's what they call a post hoc argument. It's something that has no contemporaneous record. It's after the fact. And so the theory is after the fact, and therefore there could be, I guess, facts to back it up, but there are also no facts to back it up, which is why it's so precarious and why you think it would have been thrown out as being unsubstantiated in both fact and law. Trump is actually arguing, and this is about the first time that he's argued this, Mark, about a year after he left office, that he made some of these documents unclassified and he designated them as his personal records. And so his argument goes that he just took personal records with him. Now, Reagan was allowed to take, under the Presidential Records Act, some notes that he had himself written. This is totally distinguishable, Mark. It has no basis at all. These are not personal notes that Trump made. What these are military intelligence reports, top secret national security documents that were generated by the military and the intelligence community and shown to Trump because Trump was the holder of the office at the time. Once he's no longer holder of the office, it's absolutely clear that these are government records. And nothing that he could have done would have made them personal. So to argue now that they're personal because some right-wing legal scholar came up with this theory for him a year after he left office and he got caught with his pants down. Oh, these were personal pants, blah, blah, blah. He got caught with his pants down. And not only that, remember, this case is so open and shut, Mark. He put these lawyers and others up to lie for him, to misrepresent the situation to the government, according to the allegations. They certified that there was nothing of national security documents there. And then when they went in on a search warrant, which was granted by a neutral magistrate judge in the Southern District of Florida, not Cannon, but a neutral magistrate district judge, the FBI went in there, the national security people went in there, and they found over 30 national security documents. They probably found more, but they're going to trial on about 30 of the top secret national security documents that had these red and gold bindings. So the idea that these were personal documents of Trump is absurd and factually unsupported. And she even recognized that at one of the very few public hearings that we've had in that case. Cannon actually recognized and was very skeptical about the argument. Then about a week or two after that, she proposed this jury instruction. This was also alarming to people because why is she getting into jury instructions? They're usually negotiated a week or two before trial. By the way, she still hasn't set a trial date. So here's something that's usually done a week or two before trial. There's a non-existent trial date with this judge. And suddenly she's talking about jury instructions, which were, suppose I were to give this instruction, that they were personal, that they were just documents of Trump's, then what should I go on to put in the jury instruction? And they were alarmed that she was taking this seriously. And I think that they realized that now they have a hook to go to the appellate court and to ask, number one, that the appellate court reverse that ruling, reverse the idea of giving such a jury instruction, which is based on no facts or law, but also to order her removed from the case and have the case assigned to a different judge. So that's where that is right now. And the problem is that if a judge does something wrong in a ruling on a motion, the government can appeal in this situation. They don't have to wait for the end of the case. They can appeal. What she's done is slow walked ruling. And can the stall protect her from the writ of mandamus or the appeal that the government is going to file? And what Jack Smith is doing now, and it's very clear from the special prosecutor's latest papers, Mark, is that he's setting things up to go to the 11th Circuit and appeal her or file a writ of mandamus against her. And one last thing, I've actually handled one of those in the government, for the government, in a high-profile case. So I'm very familiar with these writs of mandamus and what's required for them.
So this is interesting because you've kind of suggested that you're not only appealing this decision that's made along the way, but you're also suggesting that the door could be open to actually initiating some kind of replacement of this judge on this case. Those are two different things.
They are, Mark, and either by way of the writ of mandamus or the appeal, a different judge could be designated. It's unusual. The general presumption is that the judge who has the case, has taken an oath to be fair and impartial. They are supposed to be able to be big enough and in heart and mind that they can be reversed and still be unbiased. People have real doubts about whether she is that model of a United States district or appellate judge that can say, you know what, but the mind is like a parachute, no good if it doesn't open at the right time. And the presumption is that all federal judges' minds open at the right time, and even having been slapped down by the Court of Appeals, and even if you're the lawyer for the person who's gotten that judge slapped down by the Court of Appeals, the judge will be very fair to the issues, the judge will be very fair to you, and the judge will be very fair to your client. And all of that people are wondering about now, because remember, she's the one who got involved in that search warrant at Mar-a-Lago that I was talking about, where Judge Cannon was selected after Trump ran up the road to get her on the case. And then she issued these orders about the search. Remember, this is the one who had the special master. The former federal judge was supposed to review everything before the FBI and the national security people could see it. And there was no precedent for it. It's like, wait a second, that happens in certain cases. It happens, Mark, with attorney-client privilege material. They bring in a taint team. But the way she was bringing in a taint team, the way she was bringing in a special master, and then she stuck to it. So she did it twice. She got reversed twice by the 11th Circuit. And that's when people started to say, you know what, is she that model of a fair federal judge? Or is she a Trumpy lawyer that he put on the court who's doing obeisance to Trump?
And when you say put on the court, this is supposed to be a random process by which this case just ended up before this judge. Do you believe that it really was completely random?
I do believe it was completely random. People used to have questions about that, used to go into court and they actually picked the judge's name out of a barrel. Now it's done by computer, and you can't sort of watch it done. I mean, you could always fix the barrel, right? But you would actually stand there with your client. And there's a great story. The case where I worked on the writ of mandamus involved John DeLorean, the automaker who got the famous cocaine charges against him, of which he was ultimately acquitted. But he had what we prosecutors, and I was a prosecutor in that office along with Adam Schiff and a couple of other notable figures at that time. And I worked on the writ of mandamus on that case. But he got what we considered in the U.S. Attorney's Office in Los Angeles, one of the best judges in the court for him. In the same way that Cannon seems like the best judge on the court, we thought that it happened completely at random. But I remember the day, if I ever wrote something about it, and I never did, I was going to call my book "Good Pick, John," because the DeLorean's lawyers, who went on to be pretty famous after the acquittal, one of the lawyers stood there right next to John. I was in the courtroom, and he turned to John and he said to him, "Good pick, John," meaning this is like "Good pick, Donald." And I think it was a pick, but the error that I think in judgment here by the prosecution, and I sing the praises of Jack Smith for all that he's done, the hard work he and his team have done. But I don't understand why he took a 1 in 3 chance of getting her by picking that district to file in. The way he filed it, he had a chance of 1 in 3, and he didn't have a chance of 1 in 20, but he had a chance of 1 in 3 of getting her.
Yeah, you talked about that before, and we have spoken of this, and you know how I feel about this case. I really thought this was the open shut case, slam dunk case. It's all so obvious. You don't need any knowledge of law. You don't need any knowledge of finance. You don't need any knowledge of any election propriety. It's simple. The guy jacked these documents. They're military documents, top secret stuff, along with thousands of other documents. He moved them to his personal residence. Then he evaded a subpoena and actively evaded the opportunities that the government was trying to give him to return those documents. It's all so straightforward. So you almost need a fix-in type situation like this for Trump to evade justice. And it looks as though he's gotten this. Now, I want to ask you about the Jack Smith part. So Jack Smith has clearly in frustration. I mean, at some point, as you sort of suggested, he's saying, hey, we've got to now appeal this decision. Can you handicap that process both in terms of time and also in terms of success possibilities?
If the 11th Circuit gets it, right, if they understand that this is a stall, which is not in keeping with the federal rules. Yes, judges, district judges, trial judges have a great deal of discretion over their calendar. But that doesn't mean that if a judge is abusing it, this would be an abuse of discretion to slow walk this case as much as it is. Now, there are issues of national security. There are some tough issues in the case. There are a lot of motions that are pending. So the one side of it is that, look, it may be that Jack Smith wants this case to go to trial, and so does the public. And it's important for the public that this case reach a verdict before the November election. Having said that, it's rather accelerated. If you compare it with other national security cases with a lot of documents and a lot of issues like this, the case is not moving that slow. And so that's going to be the argument on one side. But if they get the idea that this case is being stalled, and obviously Judge Cannon is trying to, if you believe that she's trying to stall it, she's trying to stall it in a clever enough way. She's thinking about, will the 11th Circuit reverse me and replace me? But so they have the discretion, Mark, to do that. And in terms of the handicapping it, if she doesn't do anything, they're going to follow their writ of mandate, which is basically saying an appeal doesn't solve this problem. She hasn't issued a ruling. It's not something that we can file a successful appeal about, or maybe we can't appeal at all. But this is an extraordinary situation. It's rare. And look at what's going on. This is a clear abuse of discretion. It needs to be dealt with now. It can't be dealt with by a later appeal. It can't be dealt with by a final judgment. The need here, the public interest here, is to go to trial quickly. And if they get that argument, then what they would do is they would reverse it. They would replace her. There would be another judge picked at random. They wouldn't pick the judge. You pick it randomly again. So I guess it would be one of, if there are 3 judges possible in this case, it would be one of the other 2. One of those 2 would get it at random. And if that district judge then got the idea that this case needed to move, they would move it fast. And then if they move it too fast, that'll be Trump's issue on appeal. If he gets convicted, he'll argue that it was moved too fast. He didn't have enough time. And that's, I think, a very compelling argument for the average lawyer. You know, 1 or 2 lawyers are defending somebody. There are limited resources. With Trump's resources and Trump's lawyers, I don't think it would be reversed. In other words, if he's found guilty and he's convicted and sentenced, and he's looking to the Court of Appeals to then spare him because he had too speedy a trial, his lawyers didn't have the time to get ready for it, to file the motions. In his particular case, with his number of lawyers and his huge resources that he can spend, you know, if he says it was too much for my 4 lawyers, they're going to say, why didn't you have 10 lawyers? You could have afforded it. Put 1 on each motion, get this case ready for trial.
In a home run move, true or false, former federal prosecutor David Katz, Eileen Cannon, judge in the Florida case, could dismiss the charges against Donald Trump, say that there's not a case here?
Here's how this works. Once jeopardy attaches, you can't have double jeopardy. You can't be put in double jeopardy. And therefore, if the trial goes along and she says, you know, I've heard the evidence and I'm finding you not guilty, and I'm pretty sure this is going to be a jury trial, but she can also overrule the jury. She can dismiss the case. There's certain ways. We had a judge like this in Los Angeles when I was there, and he never did that in one of my cases. But I heard, from other assistant U.S. attorneys that, the jury would be seated, jeopardy would have attached, and he would dismiss the case right then. At the very end of the government's case, the defense makes a motion. It's very standard for judgment of acquittal. And they say, look, here are the 4 elements, and here's why the government hasn't presented a case in its case in chief of why they're entitled to a guilty verdict, because they haven't proven one of the elements. The classic is you're trying to show a federal bank robbery. You never showed that the bank was federally insured. You forget to put in the evidence that the bank was federally insured. You rest, and the judge says, well, wait a second, I'm granting that motion for judgment of acquittal. Or at the end of the case, the judge finds a reason to either acquit or dismiss the case. The law, at least at that time, was that the judge gotcha. He got the prosecutor. The judge managed to do something that was unreviewable on appeal, and the defendant just walked, and you could never get him or her again because of double jeopardy. People are worried that Trump will get into some situation like that, and Cannon will spring him by her ruling once jeopardy is attached, once the trial has gotten rolling. And that's the real thing to worry about. That's the jury instruction thing. She gives that jury instruction, right? The jury instruction is totally wrong. They try to mandamus it. There's not time. To some extent, if she's being really coy and clever, that was not a very coy, clever move, because that jury instruction may have given Smith the hook to get her reversed and to get her replaced in the case. So you have to wait and see on that. But the real fear, let's assume she gives a terrible jury instruction. You can't do anything about it. The jury gets the jury instruction and they vote not guilty. This is the rarity. Some judge is trying to, put their finger on a scale of justice, and in a way that helps the defendant. But that's what they're worried about here with her and with Trump. And they want the trial to start. Now, I guess your viewers will also have this question. Can the trial even start that fast? There's 70 days under the Speedy Trial Act. So if the 11th Circuit reversed and replaced her and got a new judge, and they went to trial within 70 days saying, look, you guys have all had enough time. But it's sort of a Herculean task for the new judge. There's 12 or 13 motions pending. There's not just this one. There's motions over discovery. There's all these national security issues. And so it's fraught. It's really difficult. So if you want Katz, this case does not go to trial before the election.
Yeah, I mean, that's certainly what it appears she's been successful in doing, is dragging her feet on this. And it is the case, breaking news, that she has she's not going to throw out the case. That is to say, she's not going to dismiss the charges that Trump hoarded classified documents right now, but she still can retain that, as you say, when they impanel a jury, then she could dismiss the charges then. And then that is, as you also just said, that's when jeopardy has kicked in, or whatever your terminology was, meaning you can't try him again for this once it's been dismissed.
Right. That's what we call jeopardy attaching. Now, it may be that, it's not done in a way that really does protect it from an appeal, and that there would be some basis to. Oh,
we lose David Katz. Ask David Katz.
Mm-hmm.
David, I was just saying.
I'm really sorry about that.
That's okay. I just made a sweeping statement, and you can tell me whether it's true or not. Kim was saying, well, gee, this case it's too bad that it's not going to make it to the finish line before the election. And I was saying, yeah, that's what David is predicting. I said, but this case is very important for a reason that has nothing to do with any revelations about Trump or anything that you're going to learn about Trump as a voter. It has an important part of it, because if Trump is found guilty of this, and this is whether you can tell me this is true or not, if he's found guilty of this, he cannot be president of the United States. Am I right? Isn't it a felony?
No, but the fact that you're convicted of a felony really doesn't matter. What would have mattered if the Senate had voted with about 12 Republicans who voted to acquit him in the Senate and not to convict him. Then they could have gone on after conviction on impeachment. And that's not criminal conviction. So that's no double jeopardy. Trump can still stand trial on all these trials. But to find him guilty in the impeachment sense, then they would have gone on to the clause of the Constitution that says, and therefore disqualify him from office. And that's the way that you get disqualified. They were 10 Republican senators or so not voting to convict him in the Senate. That would have disqualified him. But no, you can run from prison. You could serve from prison. There was a jocular, I hope, article talking about him being convicted here in New York City and being at Rikers Island and being president. And, he would just see, I guess, foreign diplomats and heads of state at Rikers. They'd be, they'd go through the magnetometer, they'd be patted down, and then Macron would talk to him about whatever they needed to talk about at Rikers Island. I mean, it's so absurd.
So just to clarify, you can be a felon and be the president of the United States, correct?
Yes.
Yeah.
Well, they did. I mean, and David K. Johnston's talked about this before with Eugene Debs being, the Socialist Party guy back in the 1920s who was wrapped up. But I was under the impression that those were state charges. But clearly I'm wrong. So so this is the bizarre, again, part of American government. You can't vote if you're a felon, but you can become president if you're a felon.
It's an oxymoron, isn't it? It's a moronic oxymoron.
It really
Do we have a minute
is.
to talk about the New York case?
Yes, I would just. Katz, you dropped out. I wanted to revisit what I just said, and I'm glad we did because I was wrong. So I'm glad we. Now let's talk about the New York case, which is proceeding.
Well, it looks like that case really is going to go to trial. There's going to be jury selection. Trump has now argued that the judge should be recused twice. I don't see that happening. He seems like a very able judge. And he's argued now that under the president, this is a different thing, his presidential immunity, the case that's going to be heard in the U.S., the issue that's going to be heard in the U.S. Supreme Court in late April, and will probably get decided in late May or maybe not until June. And then hopefully, because that will be an argument that will fail to preclude the trial. So the trial will go forward after that. The question is, can the federal trial in Washington, D.C. go forward fast enough that happens, that a verdict happens, or at least the trial starts before the election. But hopefully a verdict would happen. And, if Trump is found not guilty, which I don't think is really very possible based on the evidence in the law. We all saw the marauding of the Capitol, the slates, everything else that he did, not tamping it down for 3 hours and some, hang Mike Pence, sending that incendiary message while the insurrection was going on, and we could all see it with our eyes, not tamping it down an hour into it. But anyway, I think that trial has a real possibility, even with the Supreme Court. But that issue, even with the Supreme Court not taking it until late April, I think that trial will go forward, hopefully before the election, federal court, Washington, D.C. But Trump has raised the same issue like a month, and he said, wait a second, when I approved Michael Cohen paying her, and when I reimbursed Michael Cohen, remember that's what all the counts are, because he keeps sending Michael Cohen a check, which he says are legal expenses. They weren't legal expenses. It was to reimburse Cohen for the payoff to Stormy Daniels, the adult film star. He raised that issue, and the judge said you had months and months to raise that issue. We have a motions and briefing schedule. You could have brought that. Your lawyers briefed that issue, and they know the facts of it for all the federal appellate courts. You could have brought it here and said, you know what? Under presidential immunity, you had a right to do whatever you claim you had a right to do. So no, your motion is denied. The trial is going forward. And while people are kind of dubious, remember that one came down first, and I said on your show, it's too bad that's the first one. And then the other indictments came down. But this is the first one that's going to go to trial. People need to get their heads around it. It's going to go to trial. There's a lot of documentary evidence in that case. Trump is probably going to defend that, Melania's tender sensibilities. Oh, my God, she shouldn't have found out that I cheated on her. I wasn't trying to commit any kind of federal or state election violation. Remember, they have to prove that Trump knew and intended to commit a state electoral violation. If that was not his intent, then he's only convicted of the misdemeanor. And it's really not a case, all this joking around about Rikers Island. I don't think this is a case where he gets sent to Rikers Island, even if he gets convicted of the felony. But still, it would be dramatic that he would be convicted in the case. People are very worried what happens if there's a hung jury in this case, or even worse than that. He says, you know what, I was acquitted in New York. Even a bunch of left-wing jurors in Manhattan acquitted me. But I don't see that happening. And the case doesn't entirely hinge on, a Michael Cohen, his former fixer, or Stormy Daniels. There's, as I say, a lot of documentary evidence, and there's a lot of reasons why he was committing election interference. Trump runs around the country, Mark, and he talks about election interference. He was interfering in the 2016 election because after the grab him by the you-know-what tape that everybody saw, to have somebody talk about the fact that he had an affair with her, that he paid her for sex or whatever happened between the two of them, while his wife was home with a newborn, while Melania was home with a newborn. That would have had enough of an effect, and it was a razor-thin election as it was. That might have been the reason that we got Trump all these years and we didn't have Hillary Clinton as president. And that was election interference, and I think they're going to show that that was Trump's motive.
And finally, in Georgia, Counselor, will you tell us what's going on down there? It looks like Fani Willis will continue, the district attorney there, on that case, the Georgia election interference case.
Well, I think that ruling was very defensible. I mean, by the judge down there. He hits me as a very objective judge, unbiased, and he thought that it was good cause if the special prosecutor, the one that I call the $700,000 man, the one who was the special prosecutor, a boyfriend of hers, that whenever they became boyfriend and girlfriend, and obviously there was some credibility issues over that, and the look is terrible, the optics are terrible, but that it was not an actual conflict of interest, that she didn't have an actual conflict of interest. Had he decided that she did, it probably would have entailed disqualifying not just her, but her whole office. And that definitely would have led to some substantial delay. Mark, my feeling about that case is that she personally should not handle that case. Now, I know she thinks of herself as a good trial lawyer and that she knows a lot about these racketeering charges, which I've also expressed my misgivings about, especially applied to the lower figures in the case, the lesser figures in the case. But I think that they've got to, if I were in her shoes, I would hire the best prosecutor I could. They have funds to do it. They're able to pay that other special prosecutor $700,000. Remember, they were going to hire the former Republican, I guess, governor. Hire somebody of real stature. Give them the case and don't make any of the decisions. Let that new lawyer and that lawyer's team, or let some people on her team, but she personally should get completely out of this case, not go to the meetings, not have anything to do with the decisions, have her special prosecutor and some untainted, unconnected to her as much as possible district attorneys from her office, and then get moving on it. That seems like a good judge they have. Move this case forward. Maybe make deals with some of the people, maybe sever some of the people, concentrate on Trump and the big wigs. This whole idea, this was like with the people, the marauders at the Capitol. A lot of them really cannot turn on anyone in the White House. They really cannot turn some of these people in any meaningful direction. Take the big fish, sever the case, take the big fish, Trump, Giuliani, Meadows, one or two others, and let's go.
Yeah, I mean, you've said that from the very beginning. You said, it's terrific that you have, cast this net so widely, but it doesn't serve. At some point, there's a diminishing return, essentially, what you were saying on it. So, David, you're going to be on, is it Fox 5 in New York? What are you doing in New York City, media-wise? Anything?
Yes, I'm probably going to do Fox 5 and some other shows tomorrow. But anybody who really wants to watch me, tune into Mark Thompson. I love being on with you. Kim, I'm sorry we didn't have a chance. I'm sorry it just my battery ran out, happens to us all. I'm sorry it happened on your show.
Well, before you go, I do have a story for you.
Please.
And it's that New York's Democratic Attorney General apparently wants the company that provided the bond, that $175 million bond for Trump in the fraud case in New York, to prove that it actually has the money. So Letitia James is asking an appeals court today to make Trump provide proof in the case of his appeal in the civil case fails. Of course, James won a $454 million judgment against Trump after he was found guilty of overinflating the value of his properties to get the more favorable bank loans. But the story is that the bond paused the judgment while Trump appeals the verdict. So if the court agrees with James, Trump has 10 days to prove the company is actually solvent. And I don't know how, I guess the company would have to provide financial details. How you do that?
Absolutely. This is normal. I see this in my criminal cases. I'm a federal criminal defense attorney. I see it with bonds. They want to make sure that the bonding agency, now normally the bond is small enough that you figure, even if it's $100,000 bail or bond, that company has, posted money. But this is an extraordinary amount. and the request is absolutely well-grounded. Because, we all know how these sagas end with Trump. We know how the Atlantic City casino saga ended. Trump walked away okay, and here he is, back in the money, back in some money. And, who got shafted on the thing in the bankruptcy court? All the people who, not all, but many of the people who lent money, the workers, that's who got shafted. Anybody who's going to go out there and vote for Trump, hero of the working man and woman, the workers always get shafted. That's what you need to remember about Trump. This stock thing, please, right? This latest stock thing, which they've called the Trump pump and dump. And this thing, this one may very well end when they're going to win the appeal. They're going to come to collect the $175 million, and the bonding agencies goes bankrupt. The dog ate my homework, right? And they don't collect. And so Letitia James is absolutely well within her rights, and that company needs to provide financial evidence, proof, certified statements that they really do have this money.
This is interesting to me because I thought that the monies that a bonding agency puts up sit in an escrow account of some kind, so they can't say, "Oh, we are bankrupt. We don't have the money after all." Is that not the way it works, David?
Because it's a civil bond and it's such an extraordinary amount. I'm really not an expert on this, so I'd rather defer to someone's expertise on this. But it just seems to me that you would want to see the financial statements, and you would want to see if that's really the situation, that it's sitting in an escrow account, or if it's somebody's promise to pay. This is absolutely legitimate, given that you're dealing with Trump, his history of bankruptcies and all of that. So this trial really may start in New York. I mean, it'll be fascinating. I don't think it's going to be televised. I don't know what you've heard about that, but I haven't heard anything about it being televised, even though it's in state court. It's usually up to the discretion of the judge. And so assuming that the judge has that discretion, Trump he has an ability to turn these trials into carnivals and circuses without them being broadcast.
Well, it's interesting. You're right. I mean, I think that it's a net win for Trump if anything's on television, or he literally plays the media better than any other media player on the landscape. But wouldn't you agree that this particular case, which I think is, kind of weak compared to all the other stuff sitting out there, meaning in terms of its impact, not in terms of its the damnability or how guilty he is. I just mean in terms of its ability to stick to Trump, the stink. There's much more stink on J6, much more stink on Georgia, much more stink on the documents case, in my view. But anyway, this does have one thing associated with it that does have stink to it, David Katz, and that's that it involves this affair with the porn star, even when you said it, and the Melania, the newborn. I mean, it is a kind of a bad look, and these are details in evidence, are they not?
Well, they are, and you just think to yourself, it's really kind of fascinating. Let's just think of it sort of like political scientists for a moment, right? I think it's a legal matter. It's not going to be televised, and I think the judge just feels like he has that discretion, and let's assume he has that discretion, but I don't think it's going to be televised. But from a political science point of view, you look at like Michael Cohen and Stormy Daniels. How will the swing voters really think about those people? I mean, one thing is that these are the people that Trump associated with. What do you mean nothing happened with her? There's a picture of her. We know that they were both at that resort or wherever it was. She's got an awful, the trial on TV, I guess she's going to describe again, the escapade and why she knows it was him anatomically, why she can identify him anatomically speaking. Yes, that's not a good look on TV all the time for the guy running for president, but it's what everyone said in 2016 when he came down the escalator, and ever since, all the Mexicans coming here are murderers and rapists or whatever he said. It's so outlandish, it's so terrible to lambaste a whole group of people with this untrue, right, unfair stereotype. And he's done it over and over again. You look at his latest speech, you look at some of the things that he said, people are vermin. I mean, that would disqualify you for running for city council to express that. If you really believe that, and if you say it, you must really believe it. Why else would you say it? And he says it over and over again. And all this kind of stuff, the thing that's weird about him, and you see this, Mark, that he has this huge religious evangelical support. 3 Supreme Court justices. Talk about being outcome oriented, So yes, we have. I mean, they must see him. The voters for him. Come on, the Christian evangelicals and so forth. They must see him for who he is.
Well, the evangelicals have a transactional relationship, as you've suggested, with Trump. I've always said that. So they don't care about, yeah, I get it. The Lord works in mysterious ways, imperfect vessel for the Lord's perfect plan, whatever it may be. So you're right about that. But
let me just say one more thing.
Yeah, please.
Michael Cohen, he's going to be blasted outside the courtroom. And I don't know, having Michael Cohen on the stand, I mean, I've seen him on television and stuff like that. I remember when he first came out of prison and he said he wanted to be a legal commentator. And I was on Pat Thurston's show all the time. And I said to Pat, are you going to do, you invite Katz and Cohen? I guess he's going to get first billing. I don't think she ever invited him. But, you see him on TV all the time and you think how he'd be in court. My gut feeling about him is probably a better case, politically speaking, to not have him on TV all the time. They'll report what he does anyway. And so I think, the thing is, if they find him guilty, they find him not guilty. That would be the big impact perhaps on voters. And whether it's a good look or a bad look, I think if he's convicted, found guilty by the jury in that case, and that's going to happen one way or the other. I don't think there's any way now that Trump can derail it. So that's going to happen one way or the other. And I don't know. My prediction on it, he gets convicted, but maybe only of the misdemeanor.
Oh, wow.
He gets found guilty by the jury, but only of the misdemeanor. It's very hard to show. One of his defenses could be not just that I did this not for the campaign, but I did it so that my wife
marriage.
Find out, save my marriage, and all this kind of stuff. It's embarrassing. Who wants to explain? It's humiliating. But like I said, there are some things that are very bad for him. The records, he knew those were not legal expenses, and he paid Cohen. He's a penny pincher, right? He doesn't want to ever overpay anybody. This mic isn't working. Don't pay for it, right? Don't pay for this. That's Trump. And so the idea that he would have paid Trump, he would have paid Michael Cohen twice as much as the bill. He paid him twice as much as the bill because Cohen was going to have to say that it was legal expenses and pay tax on it. So he was going to need more than the payoff money. It's geared so it was enough more of the payoff money that he was going to declare it as legal income, income from practicing law, and he was going to pay the tax on it too. It was calculated to be higher. And then month after month while he was president, from the Oval Office, he paid that money. And I've said this for a long time. If he hadn't disparaged Cohen so much, Cohen was good, Cohen was good enough for him when he was his fixer, and he was no nice guy. You'd be on the other side of a legal case from him. Believe me, he was no nice guy. He was, I think, sort of a Trump mini-me, in his rudeness and his ability to sort of do anything to win, even things that weren't ethical to win. I think that's, he's been disbarred. Cohen has all of those kinds of problems, right? But he didn't want to give him a White House job. It was like, you were good enough for me all those years, but I want somebody, who went to the Ivy League or Berkeley or something like that in my White House. And they wouldn't have gone in the White House and searched him. They wouldn't have gone to his office in the White House, I don't believe. And then, of course, Cohen is just simmering with revenge. And if they can paint him, that's what I'm saying, if he is a trial witness, if he becomes like the national symbol for revenge and just getting your own back, and he looks like he's even more vindictive than Trump. Oh, well, the world's full of vindictive people. So what that we have a revenge-oriented candidate running on the Republican ticket. So I just think on a political science thing, I think this case is going as well as it could be going, the way that it's going. And on balance, I think likely that he'll be found guilty, but maybe only of the misdemeanor because he had to intend beyond a reasonable doubt and know that he was violating state campaign finance law for it to be boosted up to a felony. So he's got about 3 or 4 different arguments. The Melania, just doing it for Melania. Oh, I knew it was a federal crime. I knew there was some federal rule about that, but I had no idea state law. I had no idea. No, I was violating state law. And remember, the feds declined this case. And they declined this case even once Merrick Garland was the U.S. attorney, and even once it wasn't a Trumpy, United States attorney in the Southern District of New York. And while the judges said you cannot present that in court, that's going to be presented outside the courtroom by how many spokespeople. That'll be the Trump line talking point day after day. Feds declined this case. Even the federal government knew. And not that they couldn't prove it or didn't want to prove it or didn't want to bother with it beyond a reasonable doubt, but their argument will be, I was acquitted. I was found clean by the feds for this, found clean by the feds already.
I think you're right. I think that's absolutely right. There still may be a little bit, to the degree that the facts of this case come out and we're reminded, there might be some reputational damage, but I think it's all kind of baked in. Trump's support is pretty unshakable. David, love that we'll be able to see you on Fox 5 in New York. All our New York City listeners and those around the tri-state area, check out David today. They're in New York City. And we look forward to your visits here with us every Thursday. It's just terrific. And we're glad we had some breaking news today, and you set us straight on any number of things. You're the best.
Mark, you have such a cosmopolitan audience. If they're driving around London in the morning, okay, Times of London Radio. I'm the only guy. Radio. You know me. You know it's my voice. I'm the only guy without a British accent.
Our favorite barrister, David Katz, everyone. How about it one more time? Thank you, David. Good seeing you. All right, David Katz, everyone. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.